After working with over 100 founders, here's everything that I've learned about protecting intellectual property. My name is Sebastian Garcia. I'm an attorney and I work with entrepreneurs and founders in scaling their companies and avoiding legal issues. And if you watch until the end of this video, I'm going to give you a concise checklist that you can implement right away and that will help you in protecting your company's intellectual property. Let's begin with a story. Meet Alex. He's the founder of Tech Spark Innovations. And he's beginning his journey of scaling up a high-flying tech company, mainly in the software space. With a bunch of excitement going around, Alex secures his first major client. And so this is a major firm that is contracting with Alex for the goal of being able to use his technology within their company to further their expansion efforts. And so Alex and his team are very excited about the new deal. They got this major corporate client and they don't want to step on any toes. So they just go right ahead, they push the deal through, they don't get it reviewed, they don't have their own contract, the deal's signed, and they think they've won at this point. And so while Alex is so focused on closing the deal, he overlooks some key considerations in the contract that the major firm presented to him. He didn't have his own attorney, they didn't review it, they really just didn't want to step on any toes because they closed this huge deal and they just want to get it through and begin the process with them. Fast forward and a competitor pops up with an eerily similar name and software product. So upon realizing the gravity of the situation, Alex and his team rush to the lawyers and try to get an idea of what they can do at this point because now there's a copycat in the industry that's diluting their product's value. Alex and his team then decide to institute a lengthy legal battle. But the problem is that because they didn't have the proper documentation in place before all of this arose, and spoiler alert, this was connected with the major firm that they signed with. So because they didn't have all the proper documentation, now this legal battle faces an uphill climb with lengthy procedures in time and also costs, which will add up rather quickly. Without the proper documentation, proving ownership and infringement is going to be a difficult case. Now with Alex's tragic story out of the way, let's try to break down what we can actually learn from this story. What are other common issues that founders face? What can we do to prevent them? And what can we do to protect our own intellectual property? Again, this is based on my experience working with over 100 founders. So this is battle-proof and tested. So for startup founders, the path to success is exhilarating, but it's not without its pitfalls. Let's explore some common challenges, like the one that Alex faced, that other founders experience when they're scaling, particularly with intellectual property protection. So the first major issue that founders often face is the failure to identify. Failure to identify your company's intellectual property assets can be a costly oversight. Think unique designs, proprietary softwares, and even a secret sauce recipe. All of these things could be considered your intellectual property. And if that seems confusing right now, later in this video, we're going to cover the exact types of intellectual property. So an actionable step here is to take inventory of your intellectual property. Have a detailed list of what your company's IP is, from source code to copyrights to logos and to trade secrets, which encompass a broad range of concepts like your customer data and your business plans. And we will break that down a little bit further later. Also, when you're conducting this inventory, make sure to conduct regular audits, not just now, but maybe every few months or so. That way, when new innovations come up in your company, you're immediately categorizing them and recognizing them properly as intellectual property. The second issue that founders face is that they delay in protecting their IP assets. In the startup world, as you know, things move very quickly, so time is always of the essence. A delay in securing the appropriate patents, trademarks, copyrights, and documentation of your confidential information can leave your innovations at risk to a competitor during that gap of time that you don't take the appropriate steps. A third issue, and one that was definitely faced with Alex in the story that we shared, is inadequate documentation. Imagine this, you've created this revolutionary product, maybe it's still in the idea phase or the research and development phase, but you haven't actually taken the proper steps to document and verify that you actually, or maybe your business, is actually the owner of this property. Inadequate documentation can lead to disputes over IP ownership. And this doesn't just mean disputes with competitors. It can also mean disputes internally with co-founders, executives, employees that you bring on to help design the technology, and even contractors that you hire for one-off projects to help work on developing your intellectual property assets. So an actionable step, make sure you keep records and documentation of who owns the IP now and who owns it in the event of a change of control or an assignment. The fourth issue that founders face is improper use of IP. This means using someone else's intellectual property by mistake, or maybe intentionally, which can cause legal disputes. Whether it's copyrighted content or protected trade secrets, improper use can lead to infringement claims and costly litigation. So think what Alex did when he sued the competitor once he found out that his IP was being infringed upon. And so a real-world example is Twitter, or now known as X, versus Threads. And so what happened was when Threads came out, which was basically like a competitor to Twitter, if you haven't heard about it, owned by Elon Musk, when Threads comes out, Elon Musk and his legal team immediately sent a cease and desist to Mark Zuckerberg, stating that Threads was actually infringing on the intellectual property of Twitter, getting those names confused, specifically the copyrights of the source code, but also trade secrets that Twitter is alleging were stolen by employees who moved from Twitter to now Meta, and then those same employees at Meta utilize those trade secrets to develop Threads. One way to make sure you avoid infringement claims is conduct proper due diligence before you launch new products or marketing campaigns. This can even be done as simply as just going on Google, typing in the keywords or the name of a company or a product. And what's also good practice is you can go on the USPTO trademark database and search it up entirely for free. The fifth issue that founders face when protecting their IP in their startup is having weak contracts. A handshake agreement may seem friendly and easy, but in the world of intellectual property and the competitive atmosphere of startups, it can be quite risky. Weak contracts with vague or even absent language as to intellectual property ownership can lead to legal disputes. So here's an actionable step. Make sure that your contracts, whether it be with vendors, customers, employees, contractors, clearly define and outline who will own the intellectual property that's created and who will own the intellectual property that is included as part of a service. So one way to think about this is that if I own a software company and I'm licensing its use to my customers, I want to be very clear in that contract with my customers that I own the intellectual property and they simply have a limited license to use that IP or the source code of my software for their own commercial advantage. But to be clear, they do not own it. The sixth common mistake that founders make is that they don't conduct regular audits. Even when you've secured your intellectual property, it's not over. If you ignore the market for infringements, you potentially run the risk that other people are using your IP in an unauthorized manner. And when it comes to trademarks specifically, you can actually lose your trademark if you don't enforce it against infringers. As previously mentioned, one easy thing you can do to conduct routine audits is check the USPTO trademark database. It's totally free and you can just Google it. Think about your intellectual property as a fortress in protecting your new business. Now let's dive into why building it matters for your business's long-term success and longevity. At its core, IP protection is truly intended to protect your business from imitators or copycats, aka sometimes your competitors. IP is what gives your company a competitive edge and sets it apart from the other companies in the marketplace that don't quite have access to your unique value proposition, whether that be through your business plans, your customer data, or your product itself. Investors will see companies that have a unique value proposition that is also backed by a sound IP structure. This will ultimately protect investors from all of the common issues that we discussed in the previous slide. And no investor wants to tie up their capital if there is too much risk involved. Your IP is also important because it creates resale and enterprise value within your company. It also creates that competitive moat and that fortress that we talked about, which will make your company incredibly attractive to a later acquirer. Protecting and identifying your intellectual property will also give your company the ability to have licensing opportunities. Licensing agreements create the opportunity for your business to have a separate source of revenue generation. It also creates the ability for you to grant access to your IP to another company in exchange for royalties or maybe even an upfront payment. One final reason why IP protection is incredibly important is that it gives you legal recourse, something that Alex from our story was lacking. IP protection provides a strong legal foundation, and if someone does in fact infringe upon your IP, you have the power and the documentation to take legal action. Now, if this has seemed abstract at all so far, let's cover the main types of intellectual property. The first main type of intellectual property is trademarks. Trademarks protect distinctive names, symbols, logos, and slogans, which identify and distinguish your products or services. They prevent others from using similar marks or names that could lead to confusion in the marketplace. Copyrights protect original, creative works of authorship. This includes literature, music, art, software, and other expressive forms. So this could be lead magnets in your company, your software. Copyright is a pretty broad protection for your company. And there's one really great benefit about copyrights that we're going to discuss in the next slide. They also give creators the exclusive right to use, perform, and take commercial advantage of the copyrights. The third major form of intellectual property is patents. Patents protect inventions and technological advancements, granting exclusive rights to use, make, and sell the invention for a limited time. It's also important to note that there are several different types of patents. The fourth main type of intellectual property, and what is actually most common for most businesses and the most practical and relevant, are trade secrets. Your trade secrets are also known as your confidential information. Trade secrets prevent your valuable business information that is ultimately what gives you your competitive advantage. Think formulas, algorithms, customer lists, customer databases, business plans, marketing plans, pricing strategy, basically anything that you have in your company that you wouldn't want the outside public to know. It can also include research and development data in building out new products. It can also include customer insights and your actual contracts that you have with suppliers and vendors. Unlike the other forms of intellectual property, trade secrets are protected so long as they remain a secret. And when I say secret, that doesn't mean you can't tell anyone. It's very reasonable that you would be disclosing trade secrets when working with certain commercial providers. One example would be in the beginning, so we can tie everything together. When Alex was negotiating the contract deal with the major firm that wanted to use his software, he was disclosing trade secrets to them. And the way he would have protected them was by making it known to that major firm that A, B, and C are protected as confidential trade secrets, and made them sign off to that, either in the form of an NDA or by including a specific clause in their agreement together. And so if you take one actionable step from this slide, here's what it would be. Review your business and think about what are some protectable intellectual property assets that I may have been overlooking because I didn't even know that they were assets. One place that I always like to look are my customer lists and my customer data. Believe it or not, acquirers will buy your company simply for the customer lists and the customer goodwill and data that you have existing. So now let's get even more practical by discussing what are the ways that you actually protect the main types of intellectual property. Trademarks are protected by registering your unique brand names, slogans, and logos with the appropriate government office to secure legal rights. You can protect your trademarks in a variety of ways. You can protect them at the federal level by filing a trademark application with the USPTO. You can also protect them at the state level by filing for trademark protections with your relevant state. And if you don't file anything, you have what's called common law protections. That protects your use of the trademarks in the geographic areas that you're already using those trademarks in. But keep in mind, this is going to be limited. If you want the most trademark protection, you'd file a federal trademark with the USPTO, which gives you nationwide constructive use of that mark. Now, the second type of intellectual property, copyrights, and I touched on this earlier, are protected automatically once they've been created. However, you can still register them with the federal government, and you will get additional legal benefits, particularly in the damages and the recourse that you can seek from infringers. But even though copyright is protected automatically, it's still very important to follow all the steps that we've discussed, specifically keeping track of what copyrights you have and notifying those that you do business with, whether they're employees, contractors, or vendors and customers, that these are your copyrights and they're owned by you, and you put them on notice of it. Now, to protect your patents, you would file a patent application. This is to protect your inventions and your technological innovations from being used, replicated, and sold by someone else. So lastly, and again, the most relevant, are your company trade secrets, also known as your confidential information. You can protect these by implementing strict confidentiality agreements and taking strict security measures to make sure that your valuable business information is in fact kept confidential and secret. You can do this in large part by making sure that when you're negotiating deals and even closing deals, once you've consummated that relationship and you start working together with, let's say a service provider, that you actually have in your agreements confidentiality protections. And so if you're still in the negotiation phase, this would be done through an NDA. And if the deal has already closed, you ideally want in that agreement that you've used to consummate the transaction some sort of confidentiality protections. So to wrap everything up and to make good on my promise, I'm going to give you a checklist of actionable steps that you can take after this video to make sure you can protect the intellectual property that you have in your business. And in addressing that checklist, we're also going to discuss what could Alex have done in the story that we shared in order to have prevented all of the bad legal stuff that ensued. So the first thing you want to do to avoid Alex's situation is to identify and document your intellectual property. If you don't know what your IP is, how can you protect it? So make sure you take inventory of what IP assets you own in your business, and then take the steps to notify others when you're doing business with them what your IP is. That way, there are no confusions as to ownership. The second step that I would have advised Alex on would have been to trademark his brand, because if you remember, the competitor ended up using an eerily similar name and a logo. If Alex would have had his brand trademarked, he would have had a very smooth process of enacting legal recourse on that infringer. Now, the third thing you want to do is make sure you have contracts that document IP clauses. Now, in these contracts, they should be NDAs, non-disclosure agreements, but ultimately, every contract that you have, regardless of the transaction, can and should have a provision that covers confidential information and adequately addresses intellectual property ownership. Had Alex done this when he created the document and the agreement with the major firm that ultimately ended up stealing his idea, he would have had a much cleaner path to legal recourse because he would have had the proper documentation. So building off of that, you want to use NDAs or non-disclosure agreements. And now these typically will come into place before any transaction has been consummated. So think about you're selling your business, you're buying a business, you're thinking about potentially taking on an investor or bringing on a new key employee. You want to make sure that before that deal ever comes to fruition, you have NDAs in place with all of those parties, because that's going to protect your trade secrets and your confidential information if, in fact, that deal does not go through and that person or competitor ends up taking that information and using it for a commercial gain. You also want to make sure that you document your copyrights and you notify others what your company's copyrightable material is, and when you put them on notice of that, what do? You create an opportunity for legal recourse, which is ultimately what we're trying to do when we draft contracts or do anything that's fundamental and foundational from a legal perspective in the business. And so now let's assume you've done everything right, you've done all the steps that Alex should have done but didn't do. Now what can you do? Well, you should monitor those relationships. So when you have those contracts in place, let's assume that Alex closes the deal with the major firm and he does a great job, he has the right contract, but then he just forgets about it and he doesn't actually monitor that deal or monitor their actions and how they're using his technology. You want to make sure you monitor, because if any infringement happens, you can see to it right away that that problem is put out. And you can typically do that from what's called obtaining injunctive relief, which actionable step, you should have in all of your contracts dealing with intellectual property a section entitled injunctive relief or irreparable harm. So what's the final thing that I would have advised Alex on and that you can do right after you watch this video is you should conduct an educational training internally within your team, with your employees, with your contractors, letting them know what intellectual property is, how to protect intellectual property, how to handle it, how to identify it, because these are ultimately going to be the people that are using your intellectual property in the marketplace. So you want to make sure that they know how to handle and treat your intellectual property just as well as you do now that you've watched this video. So with all that being said, I know we covered a lot. If you have any questions, I'm very responsive and always available to have a chat about this stuff or answer your questions. So either feel free to shoot me an email, and one of the best places to find me is actually on LinkedIn. I'll put my URL on the slide. So let's connect, send me a connection request, send me a message, and let's talk about all things legal in your business. So there's a lot of other things that we can do, which I'd be happy to discuss. And you can also reference other videos that cover different topics, just like this one with intellectual property protection. So refer back to the checklist if you need to. There's a lot of actionable steps in this video. I hope you take them. I hope you protect your company, and I wish you all the best in your success.